Thank you, everyone, for joining us for this IDDP Research Spotlight session. I'm Margot Cuniff, Research Manager for the Institute for Data, Democracy, and Politics at George Washington University. And I'm very glad to introduce today our speaker, who is Enrique Armijo. He's a professor of law at Elon University. He's also a faculty fellow at the University of North Carolina's Chapel Hill Center for Information, Technology, and Public Life, and also at the Yale Law School Information Society Project. Professor Armijo writes and teaches on issues related to law and technology, the First Amendment, and administrative law. He is going to speak today about his IDDP funded research project called Counter Lies. And with that, I will yield over to you, Professor Armijo.
Thank you. Thanks for that introduction. Thank you all for coming. And thanks for IDDP for hosting and for supporting the project along with the Knight Foundation. I look forward to feedback. I always really enjoy presenting to non-lawyer colleagues. I find that feedback to be particularly valuable, particularly with respect to this project. I think you'll see that there are more questions than answers at this stage. But anything, anything you might, any thoughts you might have about this project would be absolutely appreciated. So this is kind of the big picture outline of the project. I'm certainly not going to talk about all of this today. You'll see there, if you look at the outline, there are a lot of cross currents, a lot of law. Certainly, as Margaret said, that's kind of my background field. I'm a First Amendment person and a law school teacher, so that's kind of where I start. But there are a lot of cross currents about epistemic philosophy, a lot of sociology of conspiracy theories. The claims that I make about epistemic motivations are kind of supported by cognitive science, computational social science, a lot of the work that many of you all do in the communications and psychology fields. And in terms of goals of the project, what I'm trying to do is use the social epistemology literature, which legal scholarship doesn't really interact with, and how that literature complicates the presumptions that underlie a lot of the First Amendment values that we use to develop doctrine in constitutional law. So the most prominent of these values, as I'm sure you've heard, is the idea that the First Amendment, the function of the First Amendment is kind of to facilitate the production of knowledge, the search for truth. As I'll talk about, that's kind of a what we call in constitutional law the marketplace of ideas, very much influenced by John Stuart Mill, which I'll talk about. And then kind of if there's inconsistencies between how the First Amendment thinks about knowledge production and how the literature of social epistemology thinks about knowledge production, what should we do about it? You know, is there a legal intervention? Is there a kind of, are there other ways to think about how knowledge is produced and how that might do more about informing doctrine? Another motivation of the project kind of arises from this sense of conflict between the law, how the law and the rhetoric around freedom of expression treats lies, how it thinks about lies, and how that might conflict with the modern information environment, which is something that we all work on in our own way. And then the last kind of goal for the project at this point is to think about what the consequences of all this are. What are the consequences for public speech rules in terms of government interventions, in terms of private speech rules, that's platform-based interventions. And this issue, both on the public side and the private side, goes really, I think, to the larger question of trust defaults. So as I'll talk about the First Amendment doctrine, the strongest driver in that doctrine that cuts across lots of areas is this distrust default. So the idea that we can't trust the government to decide what official truth is, because there are a lot of negative consequences associated with that. And when should we distrust an actor in a system when the role of that actor is to kind of manage the knowledge production environment? So as I've said, the way that I'm trying to resolve these conflicts and think them through is through the concept of knowledge production and examine how First Amendment theory instrumentalizes legal doctrine towards the goal of producing knowledge. And the story today kind of begins with a liar and it ends with a liar. And the first liar that the story starts with is Steve Bannon. So in early 2018, Michael Lewis writes this story about the Trump presidency for Bloomberg. And Michael Lewis finds that Trump is actually not that interesting to Michael Lewis. The interesting actor in the story is actually Bannon, and Lewis meets with Bannon 2 times. First time he talks about Bannon, what Bannon's motivations are, right? He says that what successfully elected Donald Trump president was anger. Lewis calls Bannon a connoisseur of anger. And then in the second meeting that Lewis has with Bannon, they're watching the State of the Union together, and Bannon kind of talks about his theory of opposition politics. And there, I'm sure many of you remember this quote where Bannon says, the way to deal with the media is to flood the zone with shit. So I don't want to give Steve Bannon any credit as an epistemological theorist, but the comment that Bannon makes, I think, raises a couple questions that are relevant to this project. The first question is, well, what does a knowledge production system that is functioning well, what does that require? What are the bases? What are the presumptions involved in a successful knowledge production system? And then what really is raised by Bannon, I think, is what happens when there are actors in that knowledge production system that are not motivated by knowledge production. They're motivated by interference with the system of knowledge production, and what that means in terms of how the system actually operates. And then, of course, kind of the related question to that second point is, how does the online communication space facilitate the efforts and the motivations of those who are motivated by interference with the knowledge production system? So 3 quick points on kind of the epistemology of knowledge production. The first is one way to kind of think about knowledge production in the abstract is a shared project among willing parties. So in the law, we think about that using the terminology in the theory of contracts. So if you think about knowledge production as a contract, there are certain duties involved with being in that contract, epistemic duties related to the success of the knowledge production system. So one of those duties, and I think probably the most important duty, is a duty that Sienna Schifrin talks about in a book that's called Speech Matters, which is the duty of sincerity, right? So if you have a process of knowledge production that is operating effectively, that effectiveness is going to depend on the degree to which actors in the knowledge production system are owing and complying with the duty to be truthful, right? If you have a duty, if the knowledge system relies on a presumption of truthfulness, then actors in that system can presume that the people other actors that they interact with in the system are being truthful. And this is a moral duty, so it can be overridden in circumstances. So certain conflicts with the duty of sincerity might cause breaches in the duty of sincerity, and in some cases that's okay, right? Duty to protect someone else to avoid a physical harm. Schifrin says in those circumstances, it's probably okay to not be truthful if you're trying to avoid a greater harm than the epistemic harm caused by not being truthful. But as a general matter, the breach of the epistemic duty of sincerity causes damage to the knowledge production system, right? On the individual level and on the collective level. The process of knowledge production, right? The march towards truth is frustrated. The breaching party is doing damage not just to the individual who is seeking to produce knowledge and who's motivated by accuracy. It's also an offense to autonomy, right? And this is the classic example of Immanuel Kant that Schifrin talks about, the idea that that being untruthful with someone is an offense to that person's autonomy. So when you have breaches of the duty of sincerity, you have both collective process harms and individualized harms that the causes malfunctions in the knowledge production system. The second point about the knowledge production system is what is a functioning system of knowledge production for? And this here brings us to Hannah Arendt, who has obviously gotten a lot of renewed attention in the age of Trump. I'd refer to Arendt here for a broader point, and in some ways a simpler point. And then that point is that you need a common, as Arendt says, you need a common set of shared facts in order to act deterministically through politics, right? If you have, factual truth informs political thought, and if you don't have a shared set of facts, you can't act through the political system to proceed towards self-determination. As she says, freedom of opinion is a farce unless factual information is guaranteed and the facts themselves are not in dispute. And this obviously goes back to Orwell, where he says the distinctive feature of the totalitarian state is that there's a lack of a common basis of agreement upon which political debates can take place. The third point about epistemic, the social process of epistemic knowledge production is this idea of epistemic authorities. And this goes back all the way back to Raz and even earlier, right? So just basically the idea that we believe all of these things that we don't have firsthand knowledge of. The only way that that can happen is through the use of epistemic authorities. And as Robert Post says, this is a rational basis because even if you don't know anything about the particular epistemic authority upon which you rely, you believe and trust in the system by which epistemic authorities are deemed to be authoritative, right? So you need epistemic authorities in order to believe things that are kind of outside of your perception to develop justified and true beliefs. So that's the system kind of as it previously existed. And Brian Leiter, who is a legal philosopher, has said that the internet has destroyed this idea of epistemic authorities. So you have the internet, which a distinguishing feature of it is to discredit the idea of expertise. You have these degradation of norms over who to believe. You have this populist-driven view of and use of the internet as kind of an express way to attack epistemic authority. So the whole concept of epistemic reliance is being attacked by the way that individuals in the knowledge production system choose to use the internet. I'll say a little bit more about that in a couple of minutes. So those are the kind of basic underlying points about the social epistemology of knowledge production. The First Amendment has its own theory and doctrine around knowledge production, and that's represented by John Stuart Mill, the idea of the marketplace of ideas. So just briefly, for those who aren't familiar with Mill, in On Liberty in 1859, Mill says that we don't debate just to debate, right? You have the reason to permit debate as free from government interference as possible is to let wrong ideas and right ideas collide. And through that collision, you eventually reach truth, right? And Mill is not really talking about true false binaries. He says that the commoner case is the second bullet, where you have two ideas or opinions that aren't completely true or aren't completely false. But as those two ideas collide, eventually the falseness gets beaten out of the false idea, and what you're left is a idea that has become more true through that collision with falsity. And to think about Mill in modern terms, I think it's fair to say what Mill's talking about is a collective intelligence model, right? And you can think about Mill's collective intelligence model in a couple of ways. You can think about it as a search for objective truth, which is the thick version, which is how I think Mill thought about it. Or you could just think about it as a process-based collective intelligence model that's the only goal that it has, and really the only goal that it really can accomplish, is epistemic advance. So with each collision between truth and falsity, we're eventually getting closer to truth, whatever that truth might be. So under either the thick version or the thin version of the model, it relies on fair competition of ideas, right? You have to have, as a necessary predicate to the collision of truth and falsity, you have to have ideas have to be able to compete in the market so that those who are kind of individually in the market, individualistically looking for their own truth, they need the opportunity to collide with other ideas in order to make their ideas closer to the truth. So Mill understood that people don't like to be confronted with the fact that they're wrong, right? He says that what he's proposing is more kind of, for the quote, more disinterested bystander rather than the quote, impassioned partisan. So even back in 1859, Mill understood that some people are beyond persuasion, right? Despite that, even though that Mill was in some senses a realist with respect to how persuadable people can be, I think his model of knowledge production rests on some presumptions that we know just aren't present, right? Presumptions that he presumes to be present that I think are not always present, or even not often present, to be quite cynical about it, in the knowledge production system. The first, as I kind of just implied, is the idea of ethical confrontation. So if you have individuals offering true ideas and false ideas, the knowledge production model that Mill promotes presumes that these bad faith rebuttals have a function of moving towards truth. So if you do that, you have to be willing to have your false idea used in the service of truth. So you're offering it in the hope that it is leading someone or something to a greater understanding, to a greater justified belief. I think Mill also presumes that people are actually receptive to other ideas, right? And I think we know, certainly by now, that that is not always or even often the case. So Mill, in other words, presumes that actors in his collective intelligence model are seeking out, they're participating in the model for the purpose of epistemic advance, right? They want to arrive at a better, more thought through, more justifiable conclusion with respect to the things that they believe. And we know now, I think, with some degree of certainty, that that's not actually how most people in a knowledge production system are motivated, right? You're not out for epistemic advance. And when you hear an idea that does not conform with your priors, the result of that is not a rethinking of your priors, but the result of that is attitude conflict, right? So you hear a divergent view, unlike what Mill thinks, is you're going to take that into account and come to a more considered version of your own views. What actually happens in most cases is that there's attitude conflict, and then your intolerance increases and you draw negative inferences about the speaker, who you have deemed to be in a different group or have a different attitude with respect to a certain issue than you do, right? So actors in the knowledge production system that Mill proposes are motivated by truth seeking. They're not motivated by engaging with information that's going to help them form a more accurate picture of the world. They're actually motivated by things that are useful given their pre-existing views. And here the concept of Michael Warner's work on counterpublics, I think, is helpful. So within this knowledge production model, within any model, knowledge production model, there are smaller counterpublics, right, who define themselves and perceive themselves around what, not to use a normative term, but Warner talks about like the subordinate status of the counterpublic, and information is shared within the counterpublic, not for accuracy motivation, not for accuracy-based motivations, but for goal-based motivations, right? So you share motivation, you share information, and you react to information within a counterpublic for all kinds of other reasons, right? That are completely unrelated to accuracy, right? And because you're within the counterpublic, when you share your reaction to information, the returns on that are going to be even greater than they would be if you were just an actor acting in a knowledge production model with no counterpublics at all. So, and social media, as I'll talk about, as we all know, kind of compounds those returns as well. So in other words, when you share or when you react to certain information over social media, you're doing it for engagement, you're doing it for signaling, you're not actually doing it in the way that Mill describes as to try to add towards some sign of epistemic advance. What you're doing it is for your own individual motivations that are not related to accuracy at all. So given all that, so given the fact that we, the argument I think is that we overprotect some kinds of lies, that not all lies are the same. What kind of lies should we look most closely at if our goal is a well-functioning knowledge production system? And then this is the concept of the counter lie, and this is kind of probably going to look familiar for those who are working at misinformation, disinformation distinctions. But so Tushnet says that he doesn't use the term counter lie, but you have obviously a false statement, knowledge by the person that it's making it to be false, but it's also made with the intention that the receivers of that statement believe it to be true. So it's intended not to persuade, but to confuse, right? To get someone to think that what they think is true is not true. And so they're intended, as I said, to cast doubt or other aspersions on statements and beliefs that one believes to be true. And there's a couple other aspects of what a counter lie is, right? It's a violation of epistemic right. So as I said, right, if you have a right, not to the truth, but if you have the right to an environment that permits you to seek the truth, then a lie that is made with intent to get you to disbelieve something that you believe is true causes an epistemic harm, right? It causes a primary epistemic harm, or what the literature calls an epistemic wrong, right? An intentional epistemic harm. But what it also does is it causes you, excuse me, to discount or distrust everything that you believe, including the epistemic authorities on which you rely. So if someone tells you that Elvis is alive, right, they're not just trying to get you to disbelieve that he is dead. What they're trying to get you to do is to disbelieve everything that you think you know. So anything that you use to rely on the fact that Elvis is dead, when someone tells you that Elvis is alive, they're trying to get you to disbelieve those epistemic authorities. So these are what Lanny Watson calls epistemic secondary harms, right? So not just with respect to the fact itself, but it's trying to get you to lose confidence in your beliefs, right? Or in your intellectual ability more generally. So if you apply the concept of epistemic rights, then the counter lie, as I said, is a violation of the rights of the person who's participating in the knowledge production system with accuracy-based motivations. So how do counter lies collide with truth, and what happens when they do? So this part of the project relies on the literature that tries to discern what happens when someone has formed a view with respect to a fact and then exposed to a counter view which aligns with their prior ideological preference, right? So you believe A, you've come to believe B. What happens when someone challenges B and the basis for their challenge of B resonates with something that you believe your self-concept with respect to who you are? Well, what happens, I think the studies have shown, is that the counter lie wins the collision, right? So when the truth collides with the counter lie wins. Contrary opinions speed the decay of accuracy gains. When the contrary opinion resonates with some identity-based preference within the holder of the initial view. And all of this is exacerbated by the online speech environment, right? So as I said, users aren't really motivated by accuracy in the online speech environment, by gains with respect to accuracy. They're motivated by social feedback in the form of engagement. They're motivated by signaling with respect to the counter public that they're sharing within. So you have, as I said, you have collisions between truth and counter lies, and the truth is losing that collision. And instead of epistemic advance, you have epistemic harm, both primary epistemic harms and secondary epistemic harms. So a couple complications with respect to these, with respect to interventions in terms of how to solve this problem. One complication is that as a matter of legal doctrine, some lies are protected. So the kind of three of the categories of protected lies, I would say, is, the case in 1964 of New York Times versus Sullivan. You had prophylactic protection of lies to prevent chilling effects. So in other words, as you might know, in New York Times versus Sullivan, the Supreme Court says there are some lies that we have to protect from civil liability, because if we don't, then the person who is not intending to lie but accidentally lies is going to be scared to speak because of the prospect of civil liability. And that what that means is how that all cashes out is an actual malice standard for defamation. So the First Amendment requires public officials who sue for defamation to have to show a heightened knowledge with respect to the false statement. You have, and I think this is the part of lie protection that's probably most relevant to this project. You have what the Supreme Court has called harmless lies. So these are lies that are punished by the government for their falsity alone. So these are lies that the government, that the courts say don't cause a legally cognizable harm the way that defamation does, the way that the perjury does. And then the most recent example of this is a recent case called the United States versus Alvarez, where you had this a guy, Alvarez, says that he wins the Medal of Honor. Turns out he doesn't, and he's prosecuted under stolen valor law, which makes it basically a crime, a federal crime, to lie about whether or not you won a Medal of Honor. And the Supreme Court says that that prosecution of Alvarez is unconstitutional because his lie was, quote, harmless. And then you have what the not so much the case law yet, but the academic literature talks about high value lies. So these are people who lie. These are people who lie in order to kind of maybe subvert their identity in order to create in order to be able to investigate some greater harm than the lie has caused. So in other words, people who kind of apply for jobs in order to investigate commercial agriculture production, people who work as fair housing testers, who say that they're interested in a property to see if the person who's offering that property is going to treat them differently based on their race or ethnicity. Right. I think the First Amendment will eventually come to the conclusion that those lies are protected. So that's kind of complicated by the fact. So the idea of possible interventions are complicated by the fact that that some lies are protected under the First Amendment. The other problem, and very much kind of related to the first problem, is that if there is any kind of default that cuts across constitutional doctrine around speech, is the idea, and this is from the Alvarez case that I was just talking about, is that the greatest harm possible is government declarations of official truth. So this manifests itself in the case law and in the theory that the thing that we should fear the most are government interventions with respect to what is true. So the government can participate as an actor in the knowledge production system. Jen Psaki can stand up in a briefing room and say, these 5 people are spreading misinformation about the vaccine. I don't think there's a problem with that. I don't think the doctrine thinks there's any problem with that. But what government cannot do is serve as a governor or a regulator of the speech environment with respect to what is true and false. So as the Alvarez case says, as other cases say, right, the first order harm here is government declarations of truth, and not just declarations of truth, but enforcement of that official truth against people with whom the government disagrees. This is, like I said, this is throughout this is throughout the literature and the theory and the doctrine of the First Amendment. If the government makes an assessment of official truth and then can enforce that against private speakers, then that's the least free state possible, because the government is, of course, incentivized to punish those individuals with whom it disagrees, because the government wants to remain the government, or the current government wants to remain in power and in force. And if we let the government be a referee in the knowledge production system, then it's going to act in its own interest and use the tanks, right? The government is the only actor in the system that has tanks. So that would be the greatest possible harm. And not just to define falsity, but prosecute falsity. And the heuristic I kind of use, and I think other people use in their own minds, is when someone proposes a speech rule, right? Or proposes a rule that the government should enforce, you should ask yourself, well, would I want the Trump administration enforcing this rule, right? And, you know, I think we all know that the Trump administration had its own views with respect to what truth and falsity was. Those don't conform with what a lot of us believe. But if you give the government to define official truth, the default of distrust should mean that you shouldn't want any government to do that, because one day that might be a government that disagrees with what you think the truth is. But I think when you think about this concept in terms of knowledge production, when you think about good faith in the knowledge production system, and when you think about what protection of good faith persuasion requires, there might be reason to not grab onto this distrust default so tightly. So the theoretical conception of the government distrust default is largely negative, right? We don't want the government participating in the knowledge production system. But are there certain areas in the knowledge production system? Are there certain kinds of lies, right? I think that in terms of this project, that would be the way to approach to frame the question. Are there certain kinds of lies where the default shouldn't be distrust, right? Are there certain kinds of topics or demonstrably false lies about those topics where we shouldn't worry so much about official truth, and where we can kind of loosen this idea of distrust and maybe let the government participate in the knowledge production system in a way that won't cause this more serious first order harm. So how would this work? I think the goal of the project is to try to persuade the government punishment or government action, government intervention with respect to some lies, right? Lies that concern verifiable facts that can be demonstrated as true or false. Does that present a theoretical problem? I'd say at this point, no, because demonstrably false speech that is uttered with intent to deceive does not add either to the thick or the thin conception of Mill's knowledge production system of the marketplace ideas. If you think that if you happen to be a true autonomy person in the First Amendment, and you think, well, it's important for people to be able to say what they believe because that furthers self-autonomy, well, there's some utility in that, but perhaps that small amount of utility in letting people freely deceive is outweighed by the epistemic harms caused by the lies that or the counter lies that framing protects. And then there are some implementation problems that I'll have to continue to think through, right? You have intent problems. My definition of counter lie, if you remember, relies heavily on intent. What the intent was not to deceive, but also to get one to disbelieve. So that might be a difficult thing for the government to do. I would just note for now that the government does do this in other areas when it criminalizes knowing-based lies, for example, knowingly saying that you knowingly misrepresenting yourself as a federal official is punishable under the federal criminal law. So maybe there might be some superficial implementation problems that wouldn't really survive sustained examination. So then, and I'll close with this with two kind of test cases, right? So you have a couple, and we could probably think of more, and I'll probably think of more, a couple of demonstrably false statements. So the first one is, and this is talked about a lot in First Amendment literature, the idea of Holocaust denial, which is a crime in most other European countries, not a crime in the United States. Well, first, saying the Holocaust did not happen is a counter lie, right? It's trying to get the people who believe the contrary to disbelieve not just what they think, but disbelieve those authorities on which they rely to justify what they believe. So why should we protect Holocaust denial? Well, the arguments there to protect it, as you see, is that this counter speech default, which also runs across First Amendment law that I'll spend a lot of time in the eventual papers talking about, right? The default should be private counter speech rather than public declarations of what's true and what's false. You have, would we have a never forget conception around the Holocaust if we made it a crime to say that it didn't happen? That's the argument that some people make. The arguments to not protect, I think, have close to equal force, right? At least. So you have kind of the interference with knowledge production. There's nothing to be gained by individuals questioning their prior beliefs about whether or not the Holocaust actually happened, at least I don't think. And then you have these epistemic secondary harms caused by the denial, where you can, the effect of the counter lie is, gosh, if the Holocaust didn't really happen, then what can I believe anything? And I think that is a genuine secondary harm that should be taken into account. Second example, so, imagine and this is based on an actual case, imagine a Facebook post that says, vote for Hillary on Wednesday, not Tuesday, and you can do it over text, right? Again, you have kind of the existing arguments to protect that are based on government distrust, right? On the private counter speech default. But again, you have some serious epistemic secondary harms caused by the denial. You have harms to the individual that's being told that they can't vote, or that they may wind up not exercising their right to vote. So I think this is another situation in which when you have a lie that's made with intent to deceive and to get the recipient of that lie to disbelieve what they previously believed, there might be some good arguments that kind of speech shouldn't be protected just for the sake of protecting speech. And then just to close, I said I would start with a liar and end with a liar. So the second liar in the story for today is Alex Jones. So the quote on the slide is from a Sandy Hook parent named Scarlett Lewis. And Scarlett Lewis is testifying in the first defamation trial against Alex Jones. And and her lawyer is asking her on examination, why'd you bring this case? It's not just for the money, is it? And what she says is that, I brought this case because my son existed, right? And kind of after her testimony, they're interviewing her outside the courthouse, and she says, I want to usher in an era of truth. And I think that's a noble goal. I think to do that, to get closer to an era of truth, I think the law should do a better job in distinguishing among types of lies, and then give more thought to what can actually be done about it. So with that, I'm happy to hear any questions or thoughts.
Enrique, my apologies that I had to jump in quite late in the presentation. I wasn't able to show up until half an hour after. So I missed, most of the presentation, unfortunately. But I'm wondering, just based on the last pieces that I saw and heard, what you're thinking about, especially since you and I have had a conversation about the kind of ways that we need legal scholars and empirical scholars to be thinking together more, talking together more, about some of these really hard questions in the disinformation space. I wonder what you see the sort of takeaway lessons being specifically for empirical researchers. Does this change, for example, right, the sorts of questions that you're unpacking here? Does this have implications for the types of things that we should be looking at, or the ways that we should be looking at this as we're going about our empirical work on lies and disinformation?
Thanks for that. That's a great question. I'll definitely have to think about that some more. I think that to the extent that my project is trying to distinguish among types of lies, it's at least, in the project's current form, it's trying to, the primary basis for the distinction is motivation, which is a difficult empirical question, right? I mean, I acknowledge that it's really hard to say, okay, your lie was in good faith and your lie was in bad faith, so we're going to protect the good faith lie, but worry much less about protecting the bad faith lie. I mean, I recognize that that is a challenge. And I also recognize that that's a hard thing to measure, because speaking of lies, people lie about motivation, right? I mean, somebody's saying Elvis is alive, they're saying, I believe that Elvis is alive, so I think the project presumes that the people who engage in my project presumes that people who engage in disinformation in at least some sense know that that's what they're doing, which I'm still struggling on how I or anyone can kind of, put a finer point on that fact.
Yeah, and it lies at the heart of the distinction that's been in the field from the very beginning, right? Awkwardly referring to mis/disinformation, because that intent, right, is in many instances effectively impossible to ascertain. Sorry, Jeff, I saw you unmute. I'll let you jump in.
Well, thank you. Super interesting. I had one fully formed thought, and then one thought that just went in one side of my ear and out the other. So I'll see if I can retrieve it. But the fully formed thought was, so you talk a lot. We're all scholars here. So immediately when you talked about sort of these systems of knowledge production, I think of academia. It's different. The way that it differs from social media or news is an interesting thought. But when you think about that system, and then you articulate all these concerns about the way that the role of the government in intervening in knowledge production systems, you said nothing that was sort of context specific or system focused, right? In the sense that there was nothing different from, say, a conversation that two people might be having across a dinner table versus something that's on Twitter, versus something that's said in the peer-reviewed literature, versus something that is said on a newscast. And if the core interest here is in what the government should and should not be doing as it relates to knowledge production systems, shouldn't the nature of the system be of primary concern, not merely as a moderator of harm or a moderator of sort of relative outcomes that end up being sort of the nature of the proportional judgment, but really fundamental to the judgment itself? That a place like Twitter might need its own case law because it is a unique knowledge production system with its own, where the motives of the people who created the system might be as relevant to the motives of the liar, right? So if, for example, Twitter is created to create profit for the company, and that motive ends up creating epistemic harms, even if that motive is sort of orthogonal to accuracy versus a counter-lie motive, should that be consideration here outside of the actual individual who shared a lie?
Was that the one or both?
That was one. I would love to hear your thoughts. I don't try to remember what the other one was.
I think that's a terrific point. I mean, I think that in the United States versus Alvarez case, one of the things that kind of motivates the court's decision is that something which is basically exactly what you just said, is that you can be prosecuted for telling your wife at dinner that you want that for lying about of whether or not you won a Medal of Honor, and that just put aside the implementation problems, because you're talking about the, the theoretical problem. So I think I do have to think more about the idea that there are some knowledge production environments in which the government interventions with respect to different knowledge production environments have different effects. So, I mean, I think that's an excellent thing to think about. I appreciate that.
I'm still trying to think of what the second thought was, but I'll let someone else take the floor.
While you do, can I follow up on, so I think this is super interesting and I really enjoyed your presentation, so thank you. But I guess, sort of following from what Jeffrey was saying, do you think that I guess this is sort of an ill-formed thought, but what are your thoughts then on the sort of relative merits? Is there some, potential benefit to thinking of regulating the structures of knowledge production rather than the actual content of the speech that's being, shared, right? So that it's it on one level seems like a little bit less icky to me for the government to be sort of giving us a sense of these are the conditions under which, we know that knowledge is going to be produced in a more productive or more democratic way. And so we have an interest in sort of setting up that structure, but not meddling with what actually happens. On the other hand, I'm maybe that's just, a different way of saying the same thing. And I guess I'm wondering what your thoughts are.
Yeah, I think Cass Sunstein one time talked about the government mandating something about a web browser where when you went to CNN, it automatically had to take you to Fox News first, right? So you could, and this kind of, when I was at a law firm, there was, and now I'm not going to remember her name, but the woman who was a really the longest serving White House reporter in history. I can't, she's dead now, but she had the
Helen Thomas.
Helen Thomas. So Helen Thomas is giving this talk. She was up there for 50 years, and Helen Thomas says, well, look, all you young people are reading the internet, you go, and this isn't a particularly original thought, but the benefit of a newspaper is that you read things that you weren't intending to read, right? And that can inform your kind of the accidental consumption of information influences your own knowledge production in a way that intentional decisions with respect to what to be exposed to don't. I'll think about that some more, but my reaction to Sunstein when I saw that however many years ago was that you say that's a structural intervention, but it's totally a content intervention, right? So I think for me, when I go back and think about that, I'll for the first thing I'll have to kind of think about is what's an example of a purely structural intervention, because you almost, and I don't want to be too much of a First Amendment, law professor and problematize everything, but you almost immediately get to the content question, even when you're trying to design structural interventions. But I'll definitely give that some additional thought. Thanks for asking.
I wonder if on that to continue that thread, I would agree it's really hard to think of a structural intervention that doesn't correlate with content, but perhaps the only way that could be justified for the government if it was purely and always expansive. So I remember once I was listening to I don't remember who it was, but they had this idea of they called them democracy vouchers, where everybody gets a voucher from the government that they can use to pay for a newspaper. And the idea was that it was to revitalize local newspapers, but also create a proliferation and diversity of thoughts that you don't get in a concentrated market. And so could a system level or process level intervention for the government be justified if it is wholly expansive and never restrictive? Because there's and part of that, I mean, there's the normative argument for that, but there's also sort of, I think there's a lot of tension in the way that we think about misinformation and counter lies. On the one hand, there's the sort of, and there was even some instances in your presentation where if you dig down, you one would see these. So for example, there's the classic misinformation, like Twitter has democratized information, and so misinformation bubbles to the surface, or the system can be hacked by insincere actors. But then you mentioned the Nehan 2022 paper, and that's a paper about like climate misinformation and it's how it's displayed in the news, right? And that's an instance of powerful concentrated actors using mainstream institutions to disseminate, not in a democratic fashion, but in a very sort of propagandic fashion, misinformation. And so that's an instance where those false beliefs have propagated precisely because there's been concentrated centers of information sharing, namely mainstream news. And so that's an instance where perhaps having not, if the mainstream news had not been as powerful, or there weren't these small number of knowledge production institutions, that couldn't have been co-opted by moneyed interest rather than, epistemic interests. So might that be a domain where that could be a plausible intervention for the government, as expansive?
Yeah, that's helpful too. One of the many challenging things about this project is that, and this is most, I think, best demonstrated by the Benkler book, is that epistemic authorities are themselves goal-oriented, right? So it's like, he talks about it in terms of, Fox News and Breitbart. They are not accuracy oriented, right? They're trying to do the same things. They're trying to develop and maintain market share, and the way they do that is through an oppositional framing of facts. So yeah, and I think if you do kind of have if your default is with respect to speech is kind of libertarian, I think you do kind of think, okay, well, the role of the government is not to tell people what they can and can't say on Facebook. The goal of the government is to make sure that there are lots of different Facebooks, right? I mean, so, and that's kind of, I think that's definitely a way to think about interventions as well.
Any other questions?
I just had a thought in terms of framing it in terms of safety, because that's a huge role for the government in terms of, public safety. When you think about, seatbelts in cars, banning, advertising for smoking, etc. So where does that intersect in terms of, your speech causes me personal harm versus, shouting fire in a theater type example? Why is it so much more difficult, in terms of like online speech, counter lies, etc., versus, like I said, issues of safety?
Yeah, so I think that's a good question. The primary challenge here, I mean, the other way to kind of approach this project for somebody with somebody who's in the legal academy to approach this project, and I think the way that some people are approaching these questions is that the law is just wrong with respect to what a harm is, right? So in other words, the whole idea that we distinguish between, well, defamation is a lie that the law recognizes a remedy for, but because it causes harm to reputation. But if somebody tells you to go vote on a Wednesday instead of a Tuesday, that's not a cognizable harm. And one way to approach these questions is, well, why not? Why is that? Why should the law care about one instance and not the other? So I think the other thing, the other challenge here is to really think more about what harms are. And that's where I think I have found the epistemic harm literature to be useful, because it's a way to, if you're but to think about a lie or with an intent to deceive as a breach, that's a harm. And, what the law is going to do about that harm is a whole nother set of questions, because you do kind of have to balance what one of the quotes said is, how do you prevent some lies and protect other lies and protect other things that might or might not be lies. So that's a kind of whole nother set of balancing questions. But you're exactly right that part of this is just harm recognition and the cognizability of certain harms, but not others, under the existing legal regime.
Enrique, this isn't, the case isn't about lies and disinformation per se, but I wonder if along these lines, you have any thoughts about the potential of the Supreme Court, just agreeing to take up Counterman v. Colorado, and consider the idea of true threats.
Yeah, so then, the true threats case is a pretty a pretty technical issue with respect to mens rea. I think, I'm actually not sure how that case, if I had to predict how that case is going to come out, it's going to come out on that the test is going to be what someone intended rather than what another person perceived, which I don't think is a great result, but I think it's motivated by a lot of things, including some of the things I'm talking about, like the idea that you don't want a person that's. I think the case is going to be. My prediction is that the case is going to be unsatisfying, because when you actually look at some of these threats, it doesn't matter. Like if you take the point of view of the threatened or the point of view of the threatener, like this is speech that should be punished. But what you're going to see, I think, in the opinion is a lot of oratory with respect to why we should continue to have this maximalist approach to protecting speech. And I think one of the upshots of this paper is that oratory is imprecise in a way that prevents us from solving some of these problems, as you said in your first question.
We just have a couple minutes left. Any last burning question? Well, if not, Enrique, I want to thank you for taking the time to present. Again, apologies that I personally couldn't be here right up at the top, but really value the work that you're doing and really pleased that IDDP has the opportunity to support you in continuing to do this work. And please know, and Jeff and Jennifer, you're both here as well, that if you think the IDDP community can be of assistance at any point, to never hesitate to reach out.
Thank you all. This has been great and very helpful. I appreciate continuing the conversation, and hopefully I can get you all to actually to read some drafts at some point.
That sounds good.
Thank you.
Thank you, everyone.